Not much. How you doing?
I'm asking you, what are you doing?
Filming.
Filming what? Where's your press credentials?
Really?
Really?
The First Amendment guarantees all citizens the right to take photos of almost anything which is viewable from a public setting, with few exceptions. The 1967 Supreme Court case of Katz v. United States established the doctrine of reasonable expectation of privacy, which gave individuals the right to privacy in areas where it is reasonable to assume privacy exists, such as a telephone booth or public restroom. In 2017, Missouri District Judge Nanette Lowry issued a controversial and widely misinterpreted ruling in the case of Atkins v. Knight, which would later be affirmed by the Eighth Circuit Court. In that case, the judge cited a previous ruling from the 2004 Eighth Circuit case of Rice v. Kemper, saying, quote, "Citizens have no constitutional right to videotape any public proceedings they wish to." This statement prompted local CBS affiliate KRCG to publish an article which inaccurately interpreted the ruling as declaring that citizens do not have the right to record public officials at all. This article was met with significant backlash from the National Press Photographers Association and other legal scholars for misrepresenting the context of the ruling. Shortly after the publication of the KRCG article, several law enforcement officers began to use the ruling to deter citizens from filming them without proper understanding of either the Atkins case or the Rice case. A closer look at each case reveals that they are not referring to a right to record public officials in any capacity, but more so the time, place, and manner restrictions which apply to that right. Given that the language of the Atkins case is somewhat ambiguous and unclear, it is likely that qualified immunity would play a significant role in an officer's authority to demand citizens to stop recording them.
Photographing on a public sidewalk is not a crime in and of itself. There are limitations to the protections offered by the First Amendment. Citizens are entitled to a reasonable expectation of privacy in certain places. And in the 1967 Supreme Court case of Katz versus United States, Justice John Marshall Harlan established a two-pronged test for determining whether an individual's expectation of privacy is reasonable. The Katz test considers whether an individual has exhibited an actual subjective expectation of privacy and whether the expectation is one that society is prepared to recognize as reasonable. That being said, the First Amendment does protect the act of public photography, and the public domain extends to whatever can be seen from a public location. While citizens may assume that they have a reasonable expectation of privacy inside their homes, courts have ruled many times that photographing the inside of a home through an open window is a constitutionally protected activity. Although interactions between members of the public and law enforcement are public information, there are proper channels for retrieving that information. The right to record police is relatively fundamental, and although it has not been directly ruled on by the Supreme Court, many higher courts have affirmed this right. There are some exceptions to recording the police, and officers are generally within their authority to order citizens to film from a safe location. The time, place, and manner restrictions associated with the First Amendment also apply to recording police, and government officials are allowed to dictate appropriate locations for expressive acts. In the book, Overcriminalization, the Limits of the Criminal Law, Rutgers University law scholar Douglas Husak estimated that approximately 70% of American adults have committed a crime that could lead to imprisonment. Mr. Husak also points out that federal laws alone include around 3,000 crimes, and over half of those laws are scattered throughout various statutes that are not included in the official federal criminal code. Any citizen who wished to abide by the law to the very letter would be hard-pressed to even locate all the laws, much less draw a complete understanding of them. Mr. Husak goes on to note that in addition to these statutes, there are over 300,000 federal regulations that may be criminally enforceable at the discretion of various administrative agencies. It is all but impossible for the average citizen to garner a complete understanding of the legalities that dictate this country, and nearly every citizen is subject to being stopped by police officers for frivolous violations. What is even more concerning is that in the 1996 case of Wren versus United States, the Supreme Court ruled that officers may use any violation, no matter how trivial or victimless, to initiate an investigation. For example, an officer may stop an individual for loitering in the hopes that the individual is guilty of possessing drugs, so long as the person was actually loitering. This is what is known as a pretextual stop, and it is a common tactic used by members of law enforcement to secure more serious charges by way of investigating negligible crimes. This is not to say that policing does not serve a legitimate purpose, and law and order are essential to the success of a democratic society. But Mr. Seam's sentiment that ethics and morality have been set aside in favor of the enforcement of law bears some merit. And there is no doubt that some measure of the Constitution's spirit has been lost within the complex entanglement of its enforcement.
What's going on?
Not much. How you doing?
I'm asking you, what are you doing?
Filming.
Filming what? Where's your press credentials?
Really?
Really?
I had a great interaction with Paul.
Then how come I know nothing about this?
About filming in public?
You're filming people's private business.
In public.
That's pretty shitty, honestly.
You're entitled to your opinion.
No, that's not an opinion, that's fact.
Okay.
What's your name?
I don't have to give you my name.
What is your name?
I don't have to give you my name.
Really?
Yeah.
How about you not insert yourself in other people's business?
I'm not. You inserted me into this.
No, you inserted yourself.
How did I insert myself by standing in a public area filming matters
You're
of
in private
public?
property right now.
This is an easement, sir.
And this is not easement. You're on private
Do
property.
you want to arrest me for trespassing?
I want you to leave and
go
find
where?
something better to do with your life, because that's sad.
You want a complaint?
Do I want to complain?
Yeah, keep going down this road. You're going to get a
Go
complaint.
ahead. Here's my card. You can make a complaint.
I will. I'll call Paul.
Good, call Paul. Because what you're doing is bullshit.
So glad you ruined your whole interaction.
Thank you.